So it is a covet as we learn through the many daf in Perek Yesh Nochlin, and people's minds and hearts are in tuned to the inyanim of inheritance, yerusha, nachla. So we learn psukim, we learn mishnayos that are pretty straightforward, simple, basic rules. And I think what we see, my amad dabar, we don't see that that's the way the the world is actually dividing up their inheritance. So we invited on Rabbi Mordechai Willig, who wears many hats. He's a Rav in Riverdale, Rosh Yeshiva in YU. But I think for this presentation, we reached out to him as the Rosh Beth Din of America, and perhaps the Rav from all of these three different angles could take us from the beginning through to what the Minhag HaOlam is today, why we do this, and perhaps how we interlay this, how we are able to work aligning what the Torah requires with the secular law.
Thank you very much. This is a very thorny issue. Generally speaking, we have complete emunah that the Torah is not only absolutely true and immutable, but also that the values of the Torah are true and immutable. And therefore, we are always attempting to maintain, to the best of our abilities, the letter of the law and the spirit of the law. It's clear in the Psukim and Chumash, and as anyone learning Yesh Nochlin knows fully well, that the halacha is very clear. The Torah tells us that if there is a firstborn, he receives a double share. Other sons receive a single share, and daughters receive 0. There's not a question. Psukim mefuroshim, mishnayos mefuroshos. And yet, in many of our circles, this is not done. Ways are found, and we'll discuss them in detail, to somehow circumvent what the Torah exactly wanted, which is a pella. Usually we are very much opposed to this. And of course, whenever it comes to things of this nature, we have to be guided by the Gedolei Hador, by the giants of the generations, who teach us and inform us when we have to be strict and maintain the law of the Torah as it stands, no matter what, let the chips fall where they may, or when in certain circumstances, ways can be found to change things a little bit for a higher purpose. Again, governed by Gedolei Hador. Let's go back to the Ramah, who is certainly the Gadol Hador, and is still the Gadol Hador for Ashkenazi Jews, who was in some ways, you might call him a Renaissance man. He lived at a time when things were changing in the Jewish world and the outside world. Certain liberal winds were blowing, affecting Am Yisrael. And what was happening was that if the laws of the yerusha would be followed precisely, it would lead to terrible disunity, disputes, divisions, divisiveness within families, because the women felt disenfranchised and discriminated against. And there was some kind of a device which was introduced by the Ramah in his Shulchan Aruch. It preceded him, of course, called a shtar chatzi zachar. Let's discuss that briefly right now. What's a shtar chatzi zachar? In those days of the Renaissance, in the 16th century, if a man would have 2 sons and 2 daughters, no bechor, just to make it easy. So by Torah law, the 2 sons each get 50%, and daughters get 0. In order to maintain the peace, there was something called a shtar chatzi zachar. What's chatzi zachar mean? Let's not get too egalitarian. Give the woman a half of the share that a man gets, and that'll make her satisfied. So if there was 2 sons and 2 daughters, the 2 sons would each get 1/3, and each daughter would get 1/6. That was a shtar chatzi zachar, which is found both in Even HaEzer and in Choshen Mishpah. How does it work exactly? So just to make a long story short, what happens is that a man accepts upon himself a responsibility for an inordinate sum of money, more than he has or ever will have. And just to make it simple again, he will indemnify himself to his daughters. So let's say I guess for most people it's enough. He indemnifies himself to his daughters for $100 million. Okay. So each daughter will get $50 million. Leave what does that leave for the sons? 0. He doesn't want that. So he puts in a condition and says, if the sons who are the rightful heirs, who are entitled to 50% each, will of their own give each of their sisters 1/6 of the total estate, then this obligation is null and void. So therefore now the young men are what we call behind the 8 ball. If they don't give their sisters 1/6, they're left with 0, because creditors take priority in any inheritance, and they're left with nothing. So you're forcing their hand to, of their own, give their sisters 1/6 of the estate. They're left with 1/3 apiece. That's simple workings of a shtar chatzi zacha. Why did it fall into this use? So the Mefarshim today, you know why? Because now they want a shtar zacha sholem. They want exactly equal. That idea is found in the Ktsos HaChoshen, the classical parish from hundreds of years ago, knew about a shtar zacha sholem. And Gedolim of our time think it's a very important idea to reestablish a shtar zochar shalem in order to see to it that we al tikre shalem el shalom, that shalom, that peace and harmony, should dwell in our midst. And let me give you my personal history. 40-something years ago, Morena Rav Shechter Shlit'a asked me to write something for one of the YU publications of the rabbinical alumni, that people should know that they should have some kind of a document of this type in order to make sure that their secular will is in fact halachically binding. According to most authorities, a secular will is not binding because ein matana li'achamisa. There's a very notable exception. Rav Moshe Feinstein Zatzal seems to say that it might work on the grounds of mitzvah l'kayim divrei hames, that you're supposed to follow the words of the person who passed away. It is true that in the Shulchan Aruch it is stated, based on Rabbeinu Tam, that's only true if you actually hushlash mitchila lekach. The money was given in the person's lifetime to a third party to then give it over to the people whom he designates in his lifetime. Rav Moshe seems to think that that's only needed in order to make it actionable, because once it's in the third party's hands in escrow, he'll do what the decedent, what the person who passed away wanted. Whereas if it's still in the house of the person who passed away, they won't necessarily follow what he wants. He's no longer alive. Says Rav Moshe, if you write a secular will, which the government will force the man's wishes to be fulfilled, it's the equivalent of hushash metila lekach, and therefore it would work. I would say that most authorities are not accepting Rav Moshe's opinion. If it comes to a din Torah, it's a very complicated matter. Who do you follow? We don't want to get involved in din Torahs. So therefore, Rav Shechter Shlit'a asked me just to write up a brief document, basically a shtar zochar shol. Well, the truth is, he didn't tell me at the time, 40-something years ago, what to say. All it was as follows. I owe my two daughters $100 million. But if my sons or my rightful Torah heirs will follow what is written in my last will and testament, whatever is there, then the obligation is null and void. So then the person can tailor make his will any way he wants. He can give the money to his daughters, he can give the money to tzedakah, whatever he wants. But typically, even at tzedakah, he should not be taking the money if there's no such document, because the money belongs to the sons, not to the tzedakah. Doesn't matter what you wrote in your will. But if you have this accompanying document, so then you can owe the fortune of money to somebody else, and the sons who would otherwise get the money are stuck behind the 8 ball. They better follow the will, the rest they get nothing. So they're going to follow the will, and they give the sisters an equal share, typically today, or they give tzedakah to whatever the person left with tzedakah. Otherwise, they get nothing. This is what he asked me to do 40-something years ago. It's printed in one of the publications of the rabbinic alumni of Yeshiva. Fast forward to now, this week, 17 years ago, Parshas Noach 2007, where he asked me to do something further. He's seen so many fights in families. Get up and say the truth, that the best thing to do is a shtar zochar sholem. Just give everybody an equal share, even though it's not what it says in the Torah, but it's for a higher reason, the reason of shalom, to which I wrote something, which is called Inheritance Without a Fight, Writing a Will in Modern Times. And it starts with the pasuk we read 2 days ago. Chum said to his brothers, Adam had two sons, one killed the other because of the inheritance of the world. So problems of inheritance already go back a long, long, long time. A long time. It's really a sad fact that there are people who fight over these things, which leads to really terrible, terrible results. Splits in families, which can last forever. It's terrible. There's an expression there's a famous expression, where there's a will, there's a way. There's an expression in America today, where there's a will, there's a fight. That's a very sad comment, but unfortunately, I've seen it to be true, sadly. And what do we do to overcome this? We have to be wise and follow the Gedolei Hadar, who have taught us that nowadays things have changed. I refer you specifically to a statement in the famous sefer called the Gesher HaChaim. The Gesher HaChaim was written by Rav Tukachinsky, who's from, we'll call him a Haredi background from the old Yeshiva in Yerushalayim. He wasn't someone who could be accused of some kind of a modernism or liberalism in any which way. And he tells you the following story. The story is actually frightening. It's a story which took place in the holy city of Yerushalayim, where there was an individual who wished to be an idealist and a purist, and he left in this tavo. He was a wealthy man, that the money should be divided exactly as it says in the Torah. Habchor kibchoroso, and the girls got nothing. And what was the result? You'd think, okay, when the holy city of Yerushalayim, they're certainly going to fulfill what it says. I read you the words in the Gesher HaChaim. Listen carefully. Since the minig ola is to give for daughters, it's also the law of the land. Someone who has Eina Verosho, who was a little prescient, make sure to give his daughter one minig, two, she'll otherwise go to the secular court and get her equal share, and they'll come to a machlokes. And I quote: "The Talmud Chacham Ashir Echad Asa Maiseh v'hinchil b'tzava as kol rechush abichag Torah." Only like a Torah. Chor kibcharaso shnei varim pshutim kipshutam l'shloshim benosav lo klum. This is the sentence. One more sentence. I will say it in Hebrew and repeat it in translate English. V'hinchil sina v'tachris u'pirud b'mishpachto, and he bequeathed hatred, competition, divisiveness in his family. Ad asher amar abrios, the people who said, shelo kedai haya la'ashir rechush, it wasn't worth it to leave over property, ulahorish sina, and to bequeath hatred. He would have been better off dying penniless. This is the Gesher HaChaim, page Membeis. You can look it up. This is very serious. Very serious. We have to try to avoid such a terrible consequence. So therefore, the Shtar Zachar Shalom, to my view, is the only way to do it. There are many other ways to have some measure of fixing the problem without basing yourselves on Rav Moshe's tshuva, which, as I told you, was controversial. There is something which is called a trust. I'm not an expert in this, but I think they even call it today trust in the states, because that's the way you eliminate paying money so much in taxes to Uncle Sam. Trust, and they're revocable trust and irrevocable trust. They're not the same in law, and they may not even be the same in halacha. And I leave it to the attorneys to figure out how you deal with that. It seems to me that a trust, from what I understand it, although in American law it's what's called a beria b'fnei atzma, it's an independent entity, and for tax purposes doesn't belong not to the father, not to the son. It's taxed as a separate entity, like a corporation. Most authorities don't accept corporations as an independent entity, and it belongs to the people who own the company. So here too. So who does it belong to? So on a simple level, one can say that the trust is as follows. That the Gemara, if you're learning Yesh Nochlin, you know about this. Guf mehayom uperis liachamisa. In other words, the item itself belongs to the beneficiaries now, but the payers, the reality, the control of it, and the benefits from it only will accrue to those beneficiaries after the person passes away, which perhaps may be something which is advisable. But again, I'm very careful not to get involved in tax law. Perhaps a trust would be a way to avoid the problem. Perhaps we're not exactly sure how a trust should be treated. It may depend if it's revocable or not. An irrevocable trust, which you have no control whatsoever, and all the money is already given to your children, and you're at their mercy, is not a good idea. The Gemara Bava Metzia is very, very upset about somebody who's at the mercy of his children financially. It's a terrible thing. And the Masechta of Perek Yesh Nochlin we happen to be learning right now in our yeshiva. It's a bad thing to do. If it's revocable, then it may not pass muster in terms of the problems of yerusha. It's a little complicated. Can't go into every last detail now. There are, however, it seems to me, quite a number of things which bypass yerusha, completely bypass yerusha. I'll give an example. What if jointly owned property? Typically in America today, if I'm correct, a home, which for most people is their most valuable asset, is owned jointly by husband and wife. That's typical. There's automatic survivorship, I believe, not only in American law, but even in halacha. If the house belongs to Reuven and Rachel, and one of them passes away, automatically goes to the other spouse. That's an understanding that they had when they bought the property. In effect, was a kind of they're buying it for both of us, but the achamisa, acharecha, goes to the surviving spouse. So then, in theory, you wouldn't really require any kind of a will or a shtar chatzi zachar shalim if the only asset you have is a house. What about a bank account? Again, I believe, I'm not so sure, that most bank accounts that couples have is once again jointly held, and there's again laws of survivorship. If Reuven and Rachel have a shared bank account and one of them passes away, the other one is automatically the survivor, and it also bypasses the laws of yerusha. In my opinion, not everyone agrees with me. I think it's correct. And then, of course, there are the automatic items which go after a person passes away, such as pension accounts, insurance accounts, which all have to have a written beneficiary. Typically, it's the surviving spouse. That could also really bypass the laws of yerusha. So a person who doesn't have too much money, in theory, doesn't even need not a secular will and not a shtar shachar shalim. It just automatically passes. Nonetheless, I would think it's a good idea when a person reaches a certain age, which I've reached already, that a person should fill one of these things out, both a secular will, I'm told it's helpful for a variety of reasons, as well as should be accompanied by a shtar zachar shalim. So I will just tell you what happened in my own family when my mother passed away. My father came, he wants to rewrite his will. And since I'm a bechor, he wants to give me an extra share. I said, Abba, I've been around the block. I've seen too much. I don't want one nickel more than any of the other children in the family. And so he agreed with me. He wrote a shtar in his will. He wrote it 4 children, 2 boys, 2 girls, equal shares. And he also gave a lot of money to tzedakah, which of course I believe it was, I think he said gave 10% to tzedakah, which we divided up based on his wishes. And there was no fights whatsoever. As a matter of fact, in my own case, my brother and I were the executors. An executor, I found out in New York State, is automatically entitled to $25,000 off the top. I told my brother, I don't want one penny. I don't want no one should think that we're going to read this week. Lo somani hasharti es Avram. I don't want to get rich from this. My brother needed the money more than me at the time, but all right. It only cost us $12,500 because we know. So we gave up on our rights to that fee. Everything split down the middle. Shalom al Yisrael. That's the way it should be. And when I wrote my own, I try to follow as much as I can to the extent possible to what was done in the previous generation. I have over here a typical will, which there are those who maintain And Rabbi Zalman Nechemia Goldberg, with whom I consulted about this, he printed about this, said you should leave something. Something should be given based upon the laws of the Torah. So in the olden days, what was the something? The house. Today, the house, that's almost the only asset. So they say X $1,000, and typically Svarim. I have over here, this is just a draft for someone to use. I hereby bequeath all Jewish books and the sum of $1,000 exclusively to my Torah heirs, according to the formula for inheritance prescribed in the Code of Jewish Law. In other words, this is to be yoked with something, and everyone has their own amounts and their own situations, how they want to do that. The only purpose in their mind should be shalom between the children. That's the only goal that we have over here. Otherwise, we have no right to tamper with what the Torah says. I told you before. But the Ramah in his day, Rav Tukachinsky in his day, and Rav Zalman Nechemia Zatzal now in our days, all said the same thing. You have to do whatever it takes to make shalom. If you do that, you're not in violation of. I'm just giving you what you learned about in Yesh Nochlin. Aburi Aksanta, you learned about that. A big problem. In Perek Yesh Nochlin. How do you do that? The Gemara is very upset about somebody who is in ruach hachamim nocha imenu in certain cases. Avuri achsanta lo teve. All these are very important considerations, but the most important consideration is shalom, and therefore that's the way it is. You'll ask me, why is it that we're not standing up for what the Torah said? Rabbanim in every generation have to understand when they're able to be purists and idealists, and when they're not. And if the Gedolei Adar felt they were not, who are we to say differently? To try to impose the Torah's precise prescription on all of Achenu B'nai Yisrael would likely lead, instead of listen to what the Torah had to say, rather to fights. And fights are a terrible. There are enough fights in Klal Yisrael without having fights within families based upon yerusha. So now, in terms of the details of how one does this, so I have a document which is it's just a draft. People can tamper with it all they want. So what does it say? The person obligates himself effective immediately to my spouse, okay, if he or she survives me, or if not, to my daughters. This is just a draft, okay, in equal shares. The sum of, I don't know, I once gave a share in a wealthy community. I said $100 million. They started snickering. Not enough money. Of Ali Yin Gezok. But let's take it $100 million, okay? But not payable until 1 minute before my death. So no much company has to put money for me now. No. On the condition, I do not retract this obligation any time prior to my death. A person changed his mind. Either someone did something, Khalila, someone passed away in the interim, and there are all kinds of situations where you may want to change this, okay? And I stipulate, they're given the option, the heirs, carrying my last will and testament, etc., trust and transfers, da. If they abide by the terms of my directives, this obligation is null and void. But if they contest it, object to it, whether in a civil court or a Beis Din, the obligation is absolutely valid. Fine. Now, fine. The obligation is undertaken by a Kinyan Sudar in a Beis Din Choshev. That's interesting. Why that? If you learned a little, if you're holding Baba Basra, you also learned Baba Metzia before, if you remember, there's a thing called Asmachta, and Asmachta, which is a contingency obligation of a large amount, which is exactly what's happening over here, would require to overcome the problem of Asmachta, a Kinyan Sudar in a Beis Din Choshev. As a matter of fact, there's a beautiful, beautiful kuntris called Midor Ledor by Morena Rabbeinu of Feivel Cohen, Zeichet Tzadik Livrocha. And he contends with this Asmachta issue by putting in Kinyan Sudar, Beis Din Choshev, in order to, which according to the Ramah, can overcome these issues. There's a whole discussion, what does the Shulchan Aruch hold about this? This came up in other contexts as well, but that's no time to go into it now. Here's something which an attorney told me to add. I'll read it to you. No consideration was received by the obligor in exchange for this obligation. What's that all about? So a lawyer told him, if that's the case, if there's no consideration in secular law, this is Dvarim B'Telem. Dvarim B'Telem, you have to have consideration. That's relevant for tax purposes. Someone will say you have to give more money in taxes to the government because you have this. In your court, this is meaningless. No consideration. Of course, for halacha, you don't need consideration. You have to be a little cute. So that's why this statement was put in over here. The above conditions are made in accordance with the laws of the Torah and Talmudic jurisprudence, and the manner of the conditions which are imposed on the tribes of Gad and Ruvain, as derived from Numbers chapter 32. Okay, there are all kinds of, if you learn these sugis, you also come up with in the sugis and these mesechtas. Hein, lav, it's common, which comes first? It's not called on the mice. It's complicated. It's called, a term also from lawyers, incorporation by reference. You refer to that perek in Parshas Matos, so all the laws are incorporated. This is something which the Torah has this. The Torah has this in Siman and Ches and Even Ezer with respect to conditions about marriage. It says, if you don't want to put out the condition, just incorporate by reference. B'nei Gad and B'nei Ruvain, and it works. So it works here as well. Fine, and this is a binding Hakol Shor V'Kayim, and you sign it. You sign it. It's interesting. The question is, well, what makes it valid? What makes it valid? How does it become valid? What do you do? The answer is as follows: if I have it and keep it in my drawer, it may not be valid. People keep a lot of things in their drawers. Ideally, it should be given to the beneficiary, but you may not want to do that. Not everyone wants to know. His kids should know what he's writing, what's in his will. You don't have to give it to your children necessarily. You can give it to any Jewish person for whom we apply the principle of Zachin la'adam shelo b'fanav. That the document is given to Ruvain, and he can acquire on behalf of Shimon. So a person is a son whose name is Shimon, and he doesn't want to get involved with, gives it to an attorney who's a Jewish whose name is Ruvain. And of course, a copy should be kept with the person's will, with his important papers. One never knows how long she is going to live. This, I believe, is the appropriate way to handle this otherwise very thorny situation. Obviously, this is just an overview. You're learning Perek Yesh Nochlin. There's so many details. A good son, a bad son. You learn all about these things. If you haven't, that daf is not up to it yet. You'll get to it soon. And we try not to take things from a bad son to a good son. My recommendation, again, it's only a recommendation. Once again, the money should all go to the spouse. Now, in halacha, if the wife predeceases, so the Baal Yoresh is Ishto. So you shouldn't even need this. On the other hand, it's only if you're learning b'muchzak and not b'roy. You've learned those gemaras, and it could be a bank account that's considered to be roy. That's not. We don't really. It's just money that the bank owes you. There was a whole din Torah about this years ago. So it's worthwhile having that the will and the stars in both directions. Again, some lawyer came to me once and said it's a very bad idea. Why? Because what will happen? The man leaves all of his assets to his wife, nothing to the children, and that's a good idea because the Gemara in Baba Metzia says it's not good for the almana. She depended upon her children. The other way around, the children depend upon the almana. They'll give her the proper respect that Kibbutz Dem requires. He was worried what will happen if she will then remarry, and then by halacha, all the money goes to the second husband and leave the children with nothing. So we have this carve out where it is understood between the parties that upon the ptira of the first of the spouses, that the second spouse will then have their will, which was already crafted in the lifetime of both of them. The money should go to the children. You can never know. Nothing is. Rabbi Feivel Cohen in his piece is a very convoluted kind of obligation in case one child will go along or one child will not go along. It's too complicated for me. I try to write things in one page, and that's why we have this type of simple kind of a document which literally fits on one page. maybe 2 sides of a page if you have all the other things involved. It's pretty fairly easily understood. I recommend it very strongly. I recommend the document in general. I recommend the division of property that the Gesher Chaim implies is proper to avoid machlokes. And when I speak about this, I quote a Gemara Masechta Ksubis, the famous pasuk we say all the time, "Re'vadim levanecha shalom al Yisrael." So we typically translate it, "Re'vadim levanecha." There should be children, you have grandchildren, and shalom on Klal Yisrael. The Gemara Ksubis says no. It means shalom on your own family. That's what it means. If you have their grandchildren, there's no chalitzas, there's no problem. So here too, a person is blessed with a certain amount of money. He wants to make sure that there's shalom in the family. The greatest wish of parents that the children should get along. That's the most fervent wish of all parents. The worst thing in the world is that children are not getting along with each other. So you have to have a little foresight and do what we're saying now in order to make sure that this peace, hopefully that every parent witnesses in his own lifetime, can continue even beyond. That's my presentation. If there are questions, I'm happy to take them.
Yashikaya. So just in closing, one last question. As a Rav, so I've listened to this presentation. Baruch Hashem, my parents have taken care of this. But I'm sure there are many people listening whose parents have not taken care of this. How would the Rav suggest broaching this idea and topic to the parents? I'm sure it's based on presenting the shalom aspect, but anything specifically, how children with derech eretz and proper kibbud av v'em can present this to their parents.
That's a general question, not limited to what we're discussing here today. When parents get a little bit older, so we hope that they're wise enough to take care of their affairs generally in an appropriate fashion. But sometimes children, I think that the first prerequisite for any such conversation should be unanimity among the children. It would not be good for Reuven to go to the parents and say B, and then Shimon will say the other way around, and then you're already causing a fight for no reason and prematurely. But if the children agree that perhaps the parents are not doing what they're supposed to be doing, take care of themselves, or they're thereafter, someone should speak to them, on behalf of all the children in a nice way. I'm not limiting myself to the yerusha, the shtar chazizacha. Sometimes there's a problem, Sometimes parents, when they get older, one of their responsibilities should be to purchase a grave, karka. I believe as a person gets a little older, that's something which you don't want to leave it to your children in a sudden situation to have to scrounge and here and there. What are we going to do? That's not, you wouldn't want that. In some sforim it's written, B'shnas hayovel azos toshuvu ish alachuzasa. The person turns 50, that's when they should purchase a kever. Now, people die before 52, but we hope everyone lives at least that long. Today's world, that's what I did. And what I felt, my wife, we're turning 50. It should be a school of harichas yamim. So far it's working. We hope to work so many more years. But if the parents have nothing, and the child is, knows about it, Abba, Ima, Tati, Mami, Daddy, Mami, something to think about. It should be in America, it should be in Eretz Yisrael. The people have different wishes. The same is true when it comes to healthcare proxies. Another topic which I think is important. I believe that at some point in time, I already signed one. It's a good idea because otherwise, Chalila v'chas, a person is not 100% sound mind. And what are you going to do? What did daddy want? What did mommy want? She said this, I heard this, I heard that. If it's in writing with the signature, it's very, very helpful. And of course, the same thing I believe is true with respect to our topic, which is a will. Many, many people pass away with no will, none. It's a problem from the perspective of tax law. The government could take many more dollars if a person dies intestate. And it could also lead, in my opinion, to a worse result, which is a machlokes. If Uncle Sam takes the money, no. But if the kids are fighting about the money, that's worse. So I believe that a person should approach a parent in this fashion. Now, there could be parents who are very idealist and purist. They say, oh, what do you mean, my dear son? The Torah says I'm learning Daf Yomi Yesh Nochlin. What are you telling me? We know exactly what it says. Pull out the Gesher Achayim, page Membeis. I think it's in English too, Gesher Achayim. And just tell over this story and say that he was a very respected Jerusalem rabbi from the old school, the old Yishuv, and he felt it was true then. It's certainly true now. And I would recommend that every child recommend to the parents what I just said, that the money should go to the surviving spouse, and there should be an understanding, and should be written in, if possible, that when the second spouse passes on, that the money will go to the children in equal shares. Notwithstanding a bechor and boys, girls, that I believe is the way to ensure that the peace will be maintained, even not only until Me'av Yesrim, but even beyond Me'av Yesrim. Sadly, if there's no will like that, people start jockeying for position even before the Me'av Yesrim. I've seen that too, which is in some ways even worse. But that's the way I would approach it. But it shouldn't be with any this difference of opinion within the children themselves. That could lead to a unfortunate conclusion of a fight even in the parent's lifetime. I believe that most parents today in our society are fairly sophisticated and will agree.
Yasher
Thank you.
I
Thank you.
appreciate it.
All the best. Kol tov. Bye-bye.